Good afternoon, Your Honors. May it please the Court. Sarah Perkey for the appellant, Andrea Veith. I'd like to reserve 5 minutes for rebuttal, please.
5 minutes. All right, you may proceed.
This is a post-divorce appeal relating to mother's request for sole decision-making authority for the party's 2 minor children, as well as a civil contempt related to father's failure to timely meet his post-divorce financial obligations to mother. Beginning with the decision-making authority, the parties were married for 2 years and had 2 minor children. Mother was designated as the primary residential parent, and father exercised 108 days of parenting time, although he failed to exercise all of that time post-divorce. At the time of the divorce, the parties were able to reach timely mutual decisions for their children. They had agreed to enroll their eldest child, Jack, in counseling. They had also agreed to enroll both of their children in private school. However, within a year of the divorce, father remarried. He acquired 2 stepchildren. He moved residences, and he had a new baby. As any parent would expect, that caused that amount of change for the children caused a lot of disruption for them, and their behavior quickly deteriorated. During this time, Jack's counselor also relocated, resulting in the counselor recommending that he continue counseling but with someone different, and she made that recommendation to the parties. Now, instead of responding to mother's request to enroll the Jack with a different counselor, father simply ignored all of her communications. Father also began a passive-aggressive campaign to avoid continued counseling for Jack, refusing to pay invoices for counseling for months on end, although at this time he was making over $500,000 a year. As could be expected, the practice began to threaten discontinuation of services for Jack, which we submit is exactly what father intended to happen.
So you mentioned several things that could qualify as a material change of circumstance. Father remarries, father moves out of state. But it sounds like, though, that you're arguing really the material change of circumstances, not that. It is the way father was making decisions was the material change. Is that a fair description, or do I have that wrong?
Well, we don't really care how the court gets there. If the court wants to rely upon the fact that father had many life changes which adversely affected his children post-divorce, that would be fine with us.
Well, what bothers me, though, about that sort of approach is I would think that the material change of circumstances that justifies a change in the parenting plan would need to have some relationship to the problem you're trying to fix.
Right.
And it doesn't sound like the distance from Tennessee or the former home had some connection whatsoever, whereas decision-making, yes, may have some connection. So, I really want to know what your position is on that, because it will influence on, I think, how the court looks at this. Because if you say, well, he moved and that's been good enough for material change in circumstance in any number of cases, you should reverse the trial court here on that point. I would say, well, wait a minute, don't you have to have some connection, some tie between the material change and why it's a problem?
Yes, Your Honor. I agree with the court's analysis, and I would say that the thrust of mother's argument is really their inability to make timely mutual decisions for their children post-divorce, which was a difference than what they had while they were married.
So the trial court here made some findings about father's decision-making and seemed to rely a great deal on Dr. Woodman's testimony, I feel like, about father just processes decisions differently. Mm-hmm. I think anybody that's been married can relate to that. Sure. We all come at it in different ways. And the court acknowledged that there were different approaches, but seemed to think, well, they're just different. One's not better than the other. Your client seemed to be more reliant on professionals. That's certainly a reasonable way to father seemed to want to question that a little bit more, and more contemplative maybe is a polite way to put it. So mean, why not just say, you know, you need to go back and work on this some more, not just, we're gonna throw up our hands with a plan after a year's time?
Right, Your Honor. I think that what's really important in discussing what the court said as to different approaches, when the different approaches between two parents becomes so extreme that it results in a detriment to the children, we've got a problem. Right? We've got the case law is replete talking about how if parties get to a place where decisions are not being made, where children are being adversely affected by the failure to make timely decisions, then we're at a place that it doesn't make sense to continue with joint decision-making authority. And in speaking to that, Your Honor, I think it's very important for the court to hear that Mr. Veith never agreed to counseling, voluntarily agreed to counseling for their youngest child. After 3 months of their school begging him, having conferences with the parties and begging him to get this child into counseling, he would go to these meetings and say, yes, I hear what you're saying, I'm going to do that. And then he would later on stonewall mother, not respond to her communications, and make no attempt to try to start the counseling. It was not until the school said, we are not going to allow this child to continue attending this school unless counseling is in place. It was only then 3 months later that father actually allowed for the child to be enrolled in counseling.
Was counseling interrupted over the summer here in terms of it, that once there was the agreement or provision signed so that the child could return to school with the youngest child, was there an actual interruption in counseling services over the summer?
So during this, father testified that once the minor child was actually enrolled in counseling, he had already decided when counseling began that he was going to withdraw his consent to continued counseling over the summer because he had checked the box for the school for counseling, and so it was no longer needed. So he testified that that was his intention. Later on, the child's behavior just got worse. It got really, really bad. So at this point, the child did continue counseling in that summer, but it was very broken up. And so the parents had a more of a shared schedule over the summer, and so much of the time the child was not in counseling. So inevitably, the kid goes back to school in August, and we're back to almost in a worse place than we were when the school year ended, unfortunately. Your Honors, I think that the testimony of the child's counselor is really important for the court to review. The counselor testified in detail as to how the parties' animosity for one another had made it impossible for them to make joint decisions and how that adversely affected their children. She explained how Mr. Veith was unresponsive to her communications regarding the minor child, which undermined her ability to timely implement different therapy modalities. She testified that
This is the counselor for the child.
Yes.
Not for the parent. And then you have conflicting testimony from Dr. Woodman, though, that says...
So to clarify, Your Honor, this is the same counselor. So the counselor, there was a counselor for the minor child, and then during the school ended up saying, we would like for the parents to actually engage in some family counseling with the child to get on the same page about discipline and other things in their respective homes so that we can have a cohesive approach for Knox. And so they did actually, both of the parties did do some family counseling with Knox's counselor. Now, Dr. Woodman comes in, and he has been hired by father to simply review the record, to listen to the testimony of the parties, and based on that, he says, I think that they can.
Yeah. Okay, so we've spent all time on one issue.
I know.
I'm really more interested in
are you?
This other issue here. Am I right in reading the court's order that his determination, the court's determination on whether or not the deferred bonus would be included, all turned on his interpretation of the statute?
I don't think so. I think
No? So he wasn't saying, I look at 36-4-121 and the definition of marital property, and it doesn't fit in that definition, and therefore not included.
Well, so I do think he cited the statute, but I don't
Yeah.
think that his position is consistent with the case law. So the case law is very clear that unvested portions of a person's of a spouse's compensation are in fact marital property, so long as it's not speculative in nature.
But at no point did he analyze the language of the actual MDA, did he, to determine this wouldn't be included? I mean, where's the analysis, in this 83 pages, where's the analysis of that?
I don't think that it's in there, Your Honor.
Okay.
I know I'm over my time, so I will sit down and I
Okay.
can use my last 5 minutes to go back to that. I apologize that I wasn't focused where the court wanted me to be.
Thank you, Your Honors. Elizabeth Garrett of the National Bar. I represent Mr. Veith. That's how you say his last name. Everybody says it, Veith. I'm going to follow up, please, with you, Your Honor, Judge McBrayer, on the issue of the bonus. All right, Judge Queller did, in fact, review the language in the marital dissolution agreement, paragraph 16, when he was trying to determine what Mr. Veith owed and the bonus. And there's one section that's in parentheses, and in that section, and it says, based on that, I'm finding that the amount that Mr. Veith was paid on the 15th of December, or the beginning of December each month, is what needs to be the bonus.
Yeah.
So if I could turn to it real quick, I'll do. But he did analyze both under the statute, what constitute marital property, and under the terms of the marital dissolution
So,
agreement.
but I'm not mistaken that he looked really closely at the definition of marital property and said, in effect, this deferred bonus is not marital property.
Well, of course, because he's, analyzing marital property based on the statute, which is what we all follow. But then also, he, on page 9, paragraph 16 of the marital dissolution agreement, there is it says that on or before December 15, this fiscal year bonus with the coverture fraction of 1/4, which the parties hereby acknowledge and agree is 1/8 of the total Raymond James bonus for the purpose of clarity. Judge Queller refers to that specifically in his ruling. And so I would submit to Your Honor, that is an evidence of the court looking at the marital dissolution agreement. What made it hard for both parties to know what the amount was is because nobody would know at that time what the effective tax rate was, Mr. Veith's effective tax rate. And that was part of the problem of knowing what the amount bonus is, because we don't know what his total income for the year is. We don't know if he might have losses in income, like on stocks, and so therefore we don't know what his effect, nobody could know. So that made it hard for both parties to comply with that provision. So the court did consider that as well, Your Honor. So I would submit to Your Honor he did.
Okay, so I shouldn't be worried then with this line on page 72 of the opinion. The court finds that any income received by, I'm sorry, Mr.
Veith. Yes.
After January 8, 2020, be it fiscal year bonus, deferred compensation, stock, or otherwise, was not marital property at the time of the divorce, nor was Mr. Veith deferred compensation an asset to be disclosed pursuant to paragraph 24 of the parties' marital dissolution agreement, then citing 36-4-121.
Yes.
So if I think that is just wrong, it's not a problem because that's what they bargained for in the MDA is your point.
Yes.
Okay.
And also, too, part of the issue that Ms. Veith, raises in her appeal is the failure to disclose assets. But she's saying my client failed to disclose assets of which he wouldn't even know yet when the parties entered into this agreement. For instance, they entered into this agreement in November of 2019. They're divorced January of 2020. He has a good year in 2020, and so his bonus is then paid differently, and he gets stock. Well, he did not know that until he received that in December of 2020. He didn't know. Nobody would know, right? And so I think that's what, in part, Judge Queller is saying, like that was not contemplated in this agreement for Ms. Veith to claw into future earnings of Mr. Veith. So also, I'm sure Your Honors read that the way the bonus is paid, there's a
15%.
yes, that
over
and
3 years,
ratably over
So,
3 years.
Yeah. So
And
the court's interpretation of Section 16
yes,
is, in effect, you don't count the deferred 15%.
correct, because it's not yet been earned. And Mr. Garfinkel, who was the first witness called, and my client's boss testified, it's a retention tool. If Mr. Veith is not there on the day that bonus is paid, he doesn't get it. And it's a way to keep people there. So,
Right, but, I mean, he doesn't get it either if he's not employed and working during the years that he is married to Mrs. Veith. I mean, that's the first trigger. I have to be employed there, earning a bonus. And then, yes, I mean, I would think in most instances you would look at that and say, okay, well, you maybe not get a dollar for dollar recovery of that, but you might, apply some discount rate to determine what's the value of that expectancy if the spouse stayed around. But anyway, that's my musing, and that's not a question, so
Sure.
I'm not going to pose that.
Now-
Let me
Yes,
let me
sir.
switch gears on you, because I want to talk about the decision-making component.
Yes, Your Honor.
Part here. You made an interesting statement in your brief about, how big the hurdle is here. And I think you correctly pointed out that when we say that the burden is less when it's parenting time, we really only talk about parenting time. We don't talk about other decisions in the plan. So what is the hurdle then when you're not worried about parenting time, you're not worried about the primary residential parent, and you're just talking about some component of the plan?
yes, Your
It
Honor.
seems like to me that should be a very light hurdle to overcome.
Well, I will respectfully disagree.
Okay.
And here's why. And so we spent a lot of time looking at this because it's not clear. It doesn't specifically say, because in the statute, the B section was written in advance of parenting plans, and when we still use the word custody when we refer
Sure, yeah.
to this, right? Well, we don't use that anymore. So we've got sections in a parenting plan. They're separated. Parenting time is first, and it's very clear that Section C of this statute says, if the issue before the court is the modification of the court's prior decree pertaining to a residential parenting schedule, which is not this case, right?
Yeah.
So the lower burden does not apply here. Okay, there is a case that I found after we wrote this brief. It's Pippin v. Pippin, found at 277 Southwest 3rd, 398. And in it, it says that this court, held that the term custody as used in the statute equates to the designation of primary residential parent and matters more substantive. And I submit to this panel that decision-making is very substantive. It has its own section in the parenting plan. Our parents are very interested in it. It's not some perfunctory decisions that we make. And in this case, because Mr. Veith does earn significantly more money than Ms. Veith, he has agreed to pay 100% of the education expenses and then an income proportionate share of the other expenses, which is like 97-3. And he agreed to do that. He needs to be able to participate in these decisions. I did like what Judge Queller, how he analyzed how the parties' decision-making styles complemented one another. I'm sure Ms. Veith doesn't feel like it's very much of a compliment, but she was more quick to make decisions, and Mr. Veith was more studious. He is in finance. His brain thinks a little bit more black and white, and he needs to study. So he, Judge McBrayer, Mr. Veith and Ms. Veith lived very close to one another. He did not relocate. So I know you had mentioned that earlier. So I don't think that was part of any
But
issue.
he remarried and had a child.
Yes, he has done that, right. But their oldest child, Jack, was in counseling at the beginning of their divorce.
Counsel,
Veith's divorce.
In
Yes, Your Honor.
terms of decision-making here, though, and I understand he's got a more deliberative process, he's maybe a little more skeptical of experts than his ex-wife is. But here we're talking about months where a child is not getting into any kind of counseling. When the school's saying it's needed, when the child is no longer able to attend even a full day there, and the child, my understanding, ends up having to repeat, essentially, pre-K. And isn't that sort of a circumstance where it does suggest that we've at least hit a material change of circumstance where the trial judge should have looked at what the best interests were?
Well, I'm going to respectfully disagree. Yes, you're right. Their youngest son was enrolled in a pre-K school at St. Paul's, right? The parties agreed to St. Paul, right? And so I think my client thought he was too young to go there, but he did go there, and he was hopeful that things would get better. When the school said, okay, we are making this a mandatory, then he agreed. And if you'll recall in the testimony, those teachers said that Mr. Veith has done everything that we've asked him to do. So that's what the court relied on when it made its decision. Now, Ms. Perkey was referring to their oldest son who was in counseling during the divorce. So he was in counseling from 2019 and then fast forward to 2021. And it's my understanding in the divorce, the parties wanted their oldest son to have counseling because of the divorce. At the point where that counselor moved out of the country, the court refers to it, she made a passing recommendation that he continue counseling, and my client thought that the issues had been dealt with, the divorce issues. This is well past their divorce. And so their oldest son is also at St. Paul, and he was not required by the school to get counseling. Their youngest son, Knox, was in counseling throughout the pendency of this whole matter, right? And toward the end of the counseling, the play therapist, who is Miss Thornton, was also designated as Ms. Veith's expert, which is why we had Jay Woodman involved, made a recommendation that he be tested for ADHD. Ms. Veith filled out the survey right away. My client took about a month to do it. And Ms. Thornton's testimony at trial was she couldn't remember who was the last person to turn in their survey, my client or one of the kids' coaches. So he did it right away. Once the recommendation was that he received medication, my client agreed, and the child's had medication. So I wouldn't submit to your honors that that's too long of decision-making. I know the record is replete with information about all the decisions that they did make together, because remember, they're asking to remove all decision-making, not just in this case counseling or non-emergency health care, but extracurricular activities, the school, and the record has all kinds of information about all the extracurricular activities they were able to agree to and do together.
So the plan does have a process if the parents cannot agree, correct?
Correct. If they
And was that ever exercised in this case?
Yes, the parties did attend mediation.
Mediation, okay.
Yes, but I would say to your honors, respectfully, at that point, like, the mediation was not asked for just for that isolated issue when it occurred. In fact, the bonus issue and the contempt issues had already been raised when this counseling issue came up. So this matter was already pending. And so, let's see, my now current law partner served as the mediator for the parties, but there were a lot of things going on. So the parents did not mediate the issue of whether or not Knox or Jack needed to be in counseling in and of itself. So I can tell you, Your Honors, that I think sometimes all these issues, we've got money, we've got animosity, it kind of creates problems for, like, problem solving specifically, like what you're talking about. I would just like to say to Your Honors that Mr. Veith was successful on 5 out of 6 claims in this lawsuit. And really the one claim that she was successful on, there were 2 parts to it, and the court found that he did provide notice of the bonus or the information he was required. He just didn't pay her the correct amount when it was due. And his Judge Queller's amount was kind of in between the parties, like about the amount. So there was no agreement on what that amount is. There is a fee-shifting provision in the parties' marital dissolution agreement that makes the award of attorney's fees to the prevailing party on each claim mandatory. It says shall, and for defending a claim. And so we counter appealed that Judge Queller did not award Mr. Veith attorney's fees under the fee-shifting provision,
Okay, so-
not under the discretionary.
As
when
I'm sure you're both well aware, the Supreme Court just came
yes, Your
out
Honor.
with an opinion about
Yes.
what prevailing party means in the family law context.
Right, but it's interesting because I believe, Your Honor, that's under 103C.
3C, right?
Yes.
And you're talking about the contract.
Yes.
Yeah, okay.
Yeah, and so I was prepared to talk about that distinction. I've been waiting for the Colley case to come out for a while. So I was pleased to read it, and I think it is helpful. But I think it's interesting, Judge Queller's ruling says that Mr. Veith successfully defended these counts 1, 2, 4, and then did not award fees. And so I'm submitting to Your Honors that that is not an abuse of discretion because it's a contract, and so that he's entitled to reasonable fees. Now, we don't know what that is, but that should be remanded back to the trial court. Thank you.
I submit to the court the only real inquiry the court needs to engage in when considering this bonus is whether the deferred portions of father's bonuses earned during the marriage but paid after the divorce are marital property, okay? And the reason for that is that there is no dispute between the parties that there is no provision in their marital dissolution agreement addressing those. There's no reference to deferred compensation. There's no reference to it whatsoever, okay? And so father's taking the position that because there is no specific reference under the MDA, he should get a windfall. It should be his because it was deposited to his bank account. Well, that's clearly not what the law is. Instead, Your Honors, I would point you to paragraph 24 of the parties' marital dissolution agreement. It expressly provides that assets that are not provided for in the NDA shall be equitably divided. Here we have assets that were not specifically addressed under paragraph 16 of the marital dissolution agreement or anywhere else. Therefore, I submit that the trial court first erred in finding that the deferred portions of father's bonuses, which were earned during the marriage but paid after the divorce, were not marital property. That was error. And secondly, by failing to make an equitable division of these. Okay? Your Honors, I would also like to address briefly interest in this case. The trial court found that father was in contempt for failing to pay mother any portion of the 2020 bonus. And I think that that's important, Your Honors, because he admitted he owed mother something, but he paid her nothing. And he did that on purpose, right? Because he's the one with all the resources and she's the one with none. Your Honor, the court relied upon, or erroneously relied upon mother's purported failure to prove actual damages in order to disallow her prejudgment interest. However, the case law is very clear that she does not have that burden. The very fact that she's been deprived of assets that were hers to begin with entitles her to prejudgment interest because it's based on this recognition that a party is damaged inherently by being forced to forego the use of property that is awarded to them. And I understand that it is a discretionary decision, Your Honors. However, it has now become commonplace in our case law and under our jurisprudence to award prejudgment interest. And the reason for that, Your Honors, is very clear. It sets a very poor precedent for especially for domestic matters, where obligors don't have to pay prejudgment interest on monies that are owed to an obligee. What incentive whatsoever would they have to go ahead and pay those monies, but for the fact that they would have to pay interest thereon? As such, Your Honors, I would submit that mother is not made whole from father's misconduct unless she is awarded prejudgment interest. I believe she is also not made whole by this without an award of attorney's fees. Now, the court, I'm sorry, Your Honor, would you?
No.
The court did award mother a paltry $5,000 in attorney's fees related to this. However, the court engaged in no analysis whatsoever as to reasonableness. She was contractually guaranteed her fees. The court engaged in no analysis and instead just kind of plucked a number out of the air as $5,000. This was clearly error, and we believe that both parties' attorney fee affidavits are in the record, and we would request that the court review those for reasonableness and award mother a portion
And
of that.
that award was made pursuant to the MDA?
Yes, Your Honor. Well, I mean, I don't think he said, but I assume that it's pursuant to the MDA.
Okay.
Your Honor, with respect to father's request for attorney's fees, very quickly, I don't believe that father was a prevailing party in this litigation, and that is a requirement in order for him to be successful under the fee-shifting provision of the marital dissolution agreement. With respect to the...
But, I mean, he did get involuntary dismissal of several of the civil contempt counts here.
Right. So in looking at the counts related to the timely payment of child support and alimony, the court did dismiss those, but the court also gave mother the relief that she wanted. The court put in there that although...
Right. Well, but, so, I was quite impressed by the court's detailed findings about when these payments were actually made. I would say that the court was unimpressed with the argument that was civil contempt. Fair analysis of that?
I would agree with that, Your Honor. And so the court really focused on the fact that father had initiated the payments, although they weren't available to mother. He done that timely, but they weren't available to mother oftentimes until the 3rd or the 4th of the month, depending on bank holidays and the such.
I would suspect a lot of spouses would love to get alimony and child support by wire transfer. Yeah, that seems like a pretty nice way to handle it.
It is, Your Honor.
Okay. I know that's hard to conceive, yeah.
Yeah. Okay. That's all I got. Thank you, Your Honors.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. That concludes the call of the docket for this afternoon. We will stand in recess to the next call of the docket by the presiding judge.
All right.